Elliott Church. I am the chair of the International Law section of the State Bar of Michigan, and welcome to this presentation, which is entitled The Corporate Transparency Act, Scope, Effect, and How to Prepare. And we are truly pleased to have with us experts in this area. And one of them is Mark High. He is a member in the Detroit, Michigan office of Dickinson Wright. And that is, as I think is well known, a very large law firm, How to Prepare, situated in a variety of states as well as Canada. And Mark practices in the areas of business law, corporate finance, corporate governance, international transactions. And I think also, Mark, I read that you are the president of Canadian American Business Association presently.
Yeah, the Canada-U.S. Business Association. Thanks for that plug. And we're doing an event July 13. Publicity literally just went out 15 minutes ago on USMCA 1 year in. So let me know if anybody wants to be a part of that.
Well, I'll tell you this, if you can send me a link to that, that is something I would be interested to distribute to this section.
Yep.
If it's something that others might be welcome to attend. In any event, that is Mark High. So Mark, thank you. It was also Mark who conceived of the idea of bringing this material to the international law section. And it's relevant to all business people, and it's relevant to those of us who practice in international law as well, because foreign owners are not exempt. Our second panelist or presenter is Alexis Lupo. Alexis is the director of the Corporations Division of Michigan's Corporation, Securities, and Commercial Licensing Bureau. Alexis has been with the Corporations Division since 2009 and has had a variety of experience within the Corporations Division. Or did I understand from our conversation correctly that in fact, before you were with the Corporations Division, you were with the securities side of the house? Is that true, Alexis?
Exactly, doing securities product review.
Got it. So you've had, in fact, an even longer tenure with the state of Michigan in the area of business and commerce, but now you're director. So wonderful. I'm really glad that Mark invited you and that you were available, and we look forward to hearing what you both have to say about this. A couple notes before we kick off. One is to remind folks to mute themselves if you are not presenting or commenting. That will provide the best possible venue and experience for everyone involved. Also, if you can submit questions via chat. So chat is a function which we're probably all familiar with now. And you'll find that on the lower panel of your Zoom interface. Pardon me. But I will, yeah, if you can enter questions that you have as they come up during the presentation into the chat, then when there is a pause in the delivery of the presentation, perhaps at a time when the slides are changing, we'll introduce those questions. And I will either articulate them from the chat window, or I'll ask you if you're willing to articulate the question yourself. So please enter your questions in the chat or a note about them, and then we'll have a queue and we'll take them from there. That will provide a systematic way of addressing questions. I'll give a couple time cues as we go through. The first will be at 12:30, the next at 12:45. I would like to begin a Q&A session no later than 12:50, and we'll call it quits at 1 o'clock. Precisely, because I think many folks, including me, have meetings to attend to beginning then. So with that, thank you to Mark and Alexis, and I would ask you also to supplement the introduction I've given with anything that's pertinent here. And we look forward to hearing from you. Please take it away, Mark.
Well, great. Thanks, Elliot. Hi, Alexis. Thanks for being a part of this. Welcome to everyone. This is a critical topic that will take some time for us to get our arms around. So I'm really glad that you've taken the time to at least start this process. We've got a lot to learn. There's a lot yet to come out. The statute leaves a lot of holes. Regulations will come out really right on top of when the filing requirements kick in. Right now, we've got a lot more questions than answers. It could be a mess. So it's great to get started, to build into this, to walk into this. Really happy Alexis could join us. She's got great experience on the state side, and the state regulators have been a part of this process for a long time, as she will tell you. We're going to trade topics back and forth, so like a tennis match here. So hope we don't break your necks. Lots to go through. Let's get started. So this is the statutory background, part of the National Defense Authorization Act. You may remember that was sort of a nightmare of its own, that the Congress ended up overriding the former guy's veto. Really, it was the only veto override of that term. He had 10 vetoes, actually. I had to look that up today. And it's really a subset of the Bank Secrecy Act supplements, which is a whole nother world of complications out there, mostly that the banks have to deal with, the know your customer rules and all that. So we'll skip all of that, but this Corporate Transparency Act is a new undertaking. So Alexis, what's the intent here?
Sure. So, well, I'll get into the rationale and history, which I think will help to shape or inform that. This all started in Paris in about 32 years ago at the G7 summit. It was in 1989. And at the time, the G7 was made up of Canada, France, West Germany, Italy, Japan, the UK, and the US. And one of the things that came out of that summit was the establishment of a financial action task force. That task force initially developed and examined measures to combat money laundering. It was most concerning at the time that money laundering was occurring with drug crime proceeds. And the task force was given the responsibility of examining money laundering techniques and trends, reviewing action that had been taken at a national or international level, and setting out the measures that still needed to be taken to combat money laundering. And then about a year later, in April 1990, the Financial Action Task Force, so FATF, issued a report containing a set of 40 recommendations. And those were intended to provide a comprehensive plan of action needed to fight against money laundering. And several years later, in February 2012, the FATF reviewed and republished those 40 recommendations with the intention of strengthening global safeguards and further protecting the integrity of financial systems for these governments. And what's important to us is recommendation 24. So recommendation 24 addresses beneficial ownership reporting and indicates that governments should take measures to prevent the misuse of legal persons, so business entities, for money laundering and financing terrorism. The recommendation specifically states that countries should ensure that there's adequate, timely information regarding beneficial owners and the control of those legal persons that could be obtained and accessed by competent authorities. Recommendation 25 might also be of interest to the group. It's similar and applies to trusts. So that was where this began historically. The current positions internationally might be of interest as well, particularly to the international law section. The strongest protections against anti-money laundering are in the European Union. The EU has issued anti-money laundering directives, and the sixth directive was issued most recently in December 2020, and it must be effective this month in June 2021. And under the current rules, only individuals can be punished for the act of money laundering, but this most recent sixth directive will extend criminal liability to allow for the punishment of legal persons or entities. So I'm not sure exactly what that's going to entail, but entities will be culpable for money laundering if they fail to prevent a directing mind from within the company for carrying out the illegal activities. So that would mean if you're the CEO of a German company and you have an errant employee that is laundering money, then a US CEO will be guilty of money laundering as well as the entity itself. The beneficial owner definition and beneficial ownership threshold percentages vary from country to country. So this continuum is showing where the least reporting is required and the most reporting. In the UK, so right in the middle, it is 25% of ownership and defined as persons of significant control. But that is quite a subjective definition, what that significant control means. On the lowest end, Hong Kong and the Cayman Islands, only 10% ownership threshold for beneficial owners to be reported. And Brazil is the most reporting. All shareholders are defined as beneficial owners, regardless of their ownership percentage. And the information is publicly available in some of these instances. In the UK, the information is publicly available through the Companies House public registry, and you can even find out the month and date of the shareholder's birthday. In the Cayman Islands, directors are publicly available, but shareholders are only available to competent authorities, and they have to be filed with the registered agent. Then turning to US history, I would also add part of my biography is that I'm currently the treasurer of the International Association of Commercial Administrators, which would be my office, the corporations division equivalent around the United States, Canada, and globally. And thanks to IACA, that organization, I have already received a lot of this information, and IACA has been very active on the topic for many years. In fact, board members were called to present before the Senate Investigations Committee more than a decade ago when it was chaired by then Senator Levin. And Senator Levin, Carl Levin of Michigan, and then Senator Barack Obama in 2008 introduced the Incorporation Transparency and Law Enforcement Assistance Act. Senator Levin was definitely the spearhead behind this. And while he was in the Senate, he would reintroduce or introduce each session this legislation. Unfortunately, the legislation would go nowhere, but he kept trying. And that legislation would have placed business formation agents or attorneys of beneficial owners of business entities as those reporting parties. And it would have required the Secretary of State's office or equivalent, like in Michigan, is handled by a different department. But we would be the collection agents required to maintain the list of beneficial ownership information. Then I'll turn this over to Mark to give you some basic requirements.
Yeah, I just will interject that I ran into Senator Levin. I used to take the girls to the Memorial Day parade in East Point, blue collar suburb of Detroit. And he's walking down the middle of the street with his brother, the congressman, and shaking hands and whatever. And I was involved with this topic back then with Ann Baker, former head of Corporations Division, and the ABA Corporate Committee. And I said to him, hey, be careful on this beneficial ownership stuff. It's really going to create some problems. And he looks at me like, what planet did you just come from? And said, oh, but Europe's already doing this. And he keeps going. So that was my attempt to lobby against this. I guess it worked for 10 years, but didn't last. So anyway, yeah, let's get into this. So the basic requirements, as it's been adopted, will require reporting companies to register personally identifiable information of individual beneficial owners with FinCEN, Department of Treasury. So lots of individual elements there that we will walk through. This is going to require FinCEN in particular to really ramp up their capacity. I took a quick look today. There were over 800,000 new businesses started in the US last year. So not all of them will need to report. Well, actually, the first year, maybe all of them will need to report. So we're going to see they're going to have to hire a few more people. So let's start to look at each of these elements. Alexis.
Yes, the first element that we'll look at regarding the reporting companies. So that would be corporations, LLCs, and then other similar entities organized by filing with the Secretary of State's office or their equivalent, or tribal governments. And it also applies to non-US entities qualified to transact business in the United States. So important to note that it does apply to those non-US entities that are trying to obtain a certificate of authority to transact business in the US. And other similar entities. That part of the statute has not been more clearly defined. So we're awaiting that regulatory guidance that will be forthcoming to find out what they mean by that exactly.
Right, our partnerships in the other similar entities. I think in Michigan, you don't file in Lansing to form a partnership. Limited partnerships, that's another story, and different states will have different rules here. So we'll see how the regs treat all of that. There are certain exclusions, people that automatically do not have to register. Regulated industries makes sense. They're already being regulated. We'll look at that second one. That's probably the most important for those of us on this call. Publicly traded entities already are regulated. Then Alexis, you want to move to the next one? Governmental entities, public accounting firms, tax exempt entities, entities providing assistance or governance rights over these exempt entities, dormant entities, which is another story, and then wholly owned or controlled entities of the above. So if IBM has a subsidiary that they're forming, they don't need to report. So let's look at that, the small and medium company exemption maybe. It says that if your company has more than 20 employees, more than 5 million in revenues, and a physical presence in the US, then you don't need to register. So lots of questions come out of this. That first element, 20 full-time employees, full-time equivalents, how do you calculate that? When is it measured? Alexis and I talked about the ice cream stand, the big ice cream stand with 5 million in revenues, but they only are open 3 months a year, 4 months a year. Do they qualify or don't they? When do you count your 20 employees? On the second element, the 5 million in revenues based on the prior year's federal income tax filing. Alexis, if you want to move that forward. So that's means obviously that this exemption is not available to new entities because they haven't made any tax filings yet. And some entities don't have to file taxes, so we'll see how that works. And then finally, the physical presence requirement, how much is enough if you just have a post office box or you're sharing space at a WeWork or whatever, is that enough to qualify to exempt you from that? I guess we'll see. Alexis, do you want to talk about that new entity issue?
Yes, I would just reiterate what Mark was saying, that new entities will not be able to obtain that small business registration exemption because that 5 million in revenue is from the prior year's tax return. So they might eventually age out of the system. Even after that first year, they might age out of the reporting requirement. But on day one, that very first year, they're going to be subject to the reporting obligation.
Right, so let's look at what a beneficial owner is. The intent here is to identify individuals, identify persons. Sort of government wants us to go up the chain of ownership to find actual people and get their identifying information. So an owner that needs to report, a beneficial owner, is one who directly or indirectly through any contract, arrangement or understanding exercises substantial control over the entity. That's lots of space in there, and or who owns or controls 25% or more of the entity. That's again, lots of flexibility in there. So let's look at that second one. Exercises economic interest or control. What does substantial control mean? Owns 25% of a company. Easy if you have one class of common stock. A lot more difficult if you've got preferred stock, if you're an LLC with different membership interests, classified membership interests. Somebody has the right to appoint some directors, but not all directors, or even that right kicks in upon some default or something. Lots of uncertainty involved here. So just quickly, there are some exemptions, specifically excluded people that will not be considered beneficial owners, even if they meet some of those tests. Employees who are in that status solely from their employment status. Similarly, individuals acting as a nominee or an agent. Minors don't have to report their personal information, but perhaps their parents do. Only with a right of inheritance, having that ownership interest, that's an interesting one. And then a creditor makes sense and will be helpful, but the unless otherwise meets requirements phrase again throws some questions out there. Let's talk about what needs to get reported.
Yes. So the reporting requirements identify each beneficial owner and each reporting company. That is who is required to report to FinCEN. So what that means is the specific information of an individual's full legal name, their date of birth, their business or residence address, and then there's a unique identifying number from an acceptable identification document is how the statute's worded, which could be an unexpired driver's license or passport number or a FinCEN identifier. So if an individual wants to register with FinCEN to obtain a FinCEN identifier, they could do that and obtain that number. Getting the information to the reporting company is going to be a challenge, as you can imagine. Family-owned businesses, second and third generation companies may have challenges getting a second cousin to provide a copy of their driver's license or passport, and also telling them we need your date of birth. But the company is obligated to collect and submit that information. Another side of that coin, though, is that the obligation to affirmatively provide is not set forth in the Corporate Transparency Act. We're going to have to see how that plays out in the regulations and what relief companies will be given if they have done everything they can to collect and provide that information. But hopefully the regulations will further describe what that everything that they can entails. So then I'll turn back to Mark to talk about applicant.
Can I break in here?
Yes.
Before we go forward, I'd like to just quickly review some of the things. And so let's test my knowledge a little bit as a way of testing everyone's knowledge and understanding. So it seems to me that at the outset, there are maybe 2 or possibly 3 levels of analysis as to whether the law applies. The one being, are you the kind of company to which this applies? And then if so, are you the kind of owner to which this applies? And then thirdly, I'm not sure if I understood correctly, but is there a difference between the applicability of the law when you are forming a business or when the business is already existing? Is there a difference there? So are there these 3 distinctions, these 3 points of analysis? Did I understand that correctly?
I think you definitely understand that correctly. And you're only a couple slides away from when we're going to talk about when to file, as far as if you're a new company or an existing company. Okay. All right, cool. And then just one other sort of basic question. The idea here is to enable traceability, right, of distributions. Is that the purpose? I don't know, traceability of distributions, perhaps, but the idea of combating money laundering and the financing of terrorism is the underlying idea in preventing these shell entities that have the difficulty in traceability for law enforcement purposes.
Okay, all right. So it's to provide greater visibility into the transfer of money between owners and companies.
I think that's a good way to summarize it.
Okay, cool. Thank you. Thank you very much.
For sure.
Okay, I guess we'll, I mean, think about what they're looking for. They're looking for a filing of a new company in Iowa where Vladimir Putin is a beneficial owner, and they want Vladdy's personal information in case something, I guess, happens with that company, and maybe that prevents him from even being involved, and they go somewhere else. I don't know. That's just the extreme example, I guess.
Right, but I think it could also be used for other law enforcement purposes or fraud. For example, right now with the payroll protection plan loans, there is definitely work being done by the FBI and organizations to make sure that that money was not obtained by unlawfully by people maybe that are not beneficial owners of the entities that they are claiming to be involved with, just as an example.
Fascinating. Thank you.
Yeah. So there's one definition or one term used in this act that I think is going to be real important, especially again to the group on this call, but sort of remains to be seen, and that's the term applicants. So beneficial owners, reporting companies have to report their beneficial owners and also their applicants. An applicant being an individual files an application to form an entity or to register a non-US entity. Does that mean incorporators are now applicants? Organizers for LLCs, of course. Do existing entities, are they going to have to file applicants even if they were formed 10 years ago, 30 years ago, 100 years ago? What if that applicant is not around anymore, isn't traceable, isn't alive? I certainly incorporate companies. Am I going to have to file with FinCEN every time I do that? What about when my legal assistant is closer to the paper and she can sign it and send it in? Now does she have to report as an applicant, and for how long? And so. This one, I'm afraid, I'm hoping I'm making a bigger mountain out of this little molehill, but I guess it remains to be seen as to how important this is going to be. And there is at least one reporting obligation at this point in the statute, reporting an exempt entity. Now, why does an exempt entity have to report, and who does that? Again, sort of to be determined. But okay, so that's sort of what has to be reported. Now, who's going to report it? The obligation is on the reporting company, but do other individuals have obligations if the company doesn't pursue this? I mean, the penalties that we'll see in a couple of slides include some jail time. You can't put a company in jail, so they're looking for some individual to stay responsible here. To be responsible, to have to step up and to be chased if something isn't done right. So are those the owners? Again, are the applicants, the attorneys, the accountants? They're maybe the responsible ones with a fixed address. I wonder if they're going to become chasing us to pursue this missing information. So when do we file, Alexis?
Yes. So when to file? One would presume that the regulations are going to provide a specific date for new entities formed after that specific certain date, or it might be after the regulations become effective, we'll then have to file at the time of incorporation or formation. We don't know if that means that minute, within 24 hours, promptly. 7 business days, what those parameters actually are at this point. This could be a challenge for practicing attorneys. When forming a company, do you already know who the owners are going to be? It's not that the company hasn't told you. It might be that the company still is rounding up investors and they haven't even figured this out yet. So that could be a challenge. Existing entities formed before the effective date of the regulations will have within 2 years in which to make their initial filing. So that's the time frame that we're looking at. And then updates. Entities will have 1 year to report changes or updates to their beneficial ownership information. However, there is regulatory authority for that period to be shortened. So we'll see if the regulations do shorten that time period. So 1 year from changes or updates. For dormant companies, such as entities that are not in good standing or automatically dissolved by operation of law for failing to file their annual statements and annual reports, they're exempt for reporting until a change of beneficial ownership occurs or they cease to be dormant. Thus, if they were restored to good standing or renew their existence. Mark is going to get into this a little bit more about attorney ethical issues. And I wanted to mention a point here, though, that to remember to be a beneficial owner, you have to be a natural person. And it's very common to set up a corporation that is owned by an LLC that's in turn owned by something else until you ultimately get to natural people. And in family planning and estate planning, those are a couple reasons, or family planning, estate planning, and tax efficiency. There are very legitimate reasons for that kind of structuring. And there are going to be many times when attorneys may not know about those up the line changes. And then there is going to be a real challenge in how that information collection works. So that will be coming. And then turning to the penalties for violations. If false information is filed, who goes to jail? The officers, the directors, the beneficial owners, we don't know this yet. The way the statute is written, the company has the reporting obligation and there are penalties for violating it as shown here. So up to 2 years in jail, a fine of up to $10,000. So there's a bit of a disconnect about how this is going to play out. So stay tuned for guidance on that in the upcoming regulations. And I would mention that there are penalties for turning to that. I would mention that there are also penalties for FinCEN. FinCEN for disclosing the beneficial ownership information improperly. There could be a question that starts arising too for practicing attorneys to consider. If a company files a beneficial ownership report with FinCEN, and then in standard litigation, it could become a question on interrogatories that says, give us a copy of your FinCEN beneficial owner report. Like today, interrogatories will sometimes request a copy of an operating agreement or a copy of a share ledger, shared transfer ledger, and the statute does not seem to contain any confidentiality requirements at that level, but it's still to be determined. Then turning to who has access to the filed information. So disclosing the beneficial owner's reported information is very much restricted. The federal agencies that are involved in national security, intelligence, and law enforcement are going to have a pretty quick path to accessing the database information. There is basically then a level down for state, local, and tribal law enforcement agencies to obtain the information for criminal or civil investigations, but they must have court authorization to get the information. The Corporate Transparency Act also allows for the disclosure to a federal agency following a request from law enforcement of another country. So that's an interesting one there. And banks do have the ability to get this information to do customer due diligence, but they have to get consent from the customer to do so. There are no particular Fourth Amendment protections, and there is no notice back to the company that your information is being accessed. Then a bit of a timeline of how this rollout is going to happen. So through the Corporate Transparency Act, Treasury has 1 year after the passage to adopt rules. So that would be the rules and regulations by January 1st, 2022. Once those rules go effective, which isn't necessarily January 1st, 2022, but probably soon thereabouts, then entities are going to be subject to these new filing requirements with FinCEN, and the 2-year time clock for existing entities will begin to start. And based on conversations I've been involved with, a conference call with FinCEN, it sounds like they are pushing for the regulations to be effective in January 2022, but we'll have to wait and see if they meet their deadlines. An advance notice of proposed rulemaking was issued by FinCEN on April 1st of this year, and the comment period ended on May 5th of 2021. And I did submit comments on behalf of the State of Michigan Corporations Division. The next step in this process would be the draft regulations being released. FinCEN has indicated that they're expecting to release those in July, so next month, and a public comment period will follow, and then the final regulations. FinCEN is charged by the statute to establish a database and filing procedures before those filings commence. They have been given hiring authority, so they have that hiring authority. They certainly need to staff up, and they've been given $10 million in funding to do so. And Mark is going to talk about some of the attorney ethical issues.
Well, and yeah, we're really just guessing at these at this point, but we do have obligations of confidentiality to our clients, and so are we, if applicants are going to be required to file, if attorneys are going to be held to help enforce the reporting requirements of these reporting companies, does that violate our confidentiality obligations to clients? About to former clients, clients you haven't talked to in a couple years, a couple months, a couple decades. It's going to be real interesting to see what kind of responsibility is going to get try to get placed on us. Clearly, the ABA is looking at these things, and I'm sure they've got comments in on that, among others. But it, really sort of depends on who has the reporting obligations, which are still to be determined. As the last line there indicates, what if they were a client but they left, or you sent them away, or can you send a letter and saying I'm not responsible anymore? I mean, you're still an applicant at that point. If you did the incorporation, you can't withdraw from that. So this is really it's going to be an interesting time here.
Indeed. And then there was a question that came up in the chat about when where the regulations will be published, and they will be published at regulations.gov. That would be the US portal, if you will, for regulations to be published and for comments to also be entered. Filing offices. So state filing offices, a bit of history. In 2006, Delaware increased regulation on registered agents and required a contact person to be provided to the registered agent. So Delaware and DC have already started taking measures to start kind of obtaining little bits of beneficial ownership information, not nearly as robust as this federal legislation. And Washington, DC recently enacted a law or passed an ordinance in 2019 to require beneficial ownership reporting requirements. And in 2018, Delaware started requiring registered agents to conduct client due diligence before filing documents for a new customer. So an identification check, and also checking the SDN list, so the specially designated nationals and blocked persons list, which is published by the U.S. Office of Foreign Asset Control, or OFAC. And they also have to periodically review clients against that list. The state filing office responsibilities under this new Corporate Transparency Act, states are required to inform applicants for incorporation or organization of their obligations under the CTA and provide copies of the forms and links Notification activities are also required around the annual filing that is required by corporations and LLCs as another opportunity to remind companies of this reporting requirement to FinCEN. States are required to cooperate with and provide information requested by FinCEN for purposes of maintaining an accurate, complete, and highly useful database for beneficial ownership information. And we, as the states, have until January 1st of 2023 to become compliant in that information sharing requirement of the Act. But there's still a lot of open questions for states, and we're hoping the regulations provide more guidance. As you can imagine, while we will not be the collectors of the information, we are somewhat afraid that all of the questions are still going to come our way from businesses that don't understand the reporting requirements or whether they are required to report. So especially if we're informing them of that information, but then not the actual entity or organization that they filed to. So we're waiting to see how the regulations will specify exactly the information we need to provide.
Great.
Let me break in here just briefly to say that we're at 12:41, and it'd be good to begin a Q&A at 12:50. So that gives you about 9 minutes to wrap up. Would that be adequate?
Yeah, we're down to our last couple slides here, most of which are questions. So
okay,
we'll start this process here right away. But thanks for that update. Interesting that there's not a clock in Zoom, so I can't tell really what time it is without working at that. So here is a partial list of unanswered questions. I think there were questions almost on every slide that we've been through before, but here are a few that we've collected. Alexis, I think, had indicated, does this beneficial ownership report become available to litigants or maybe in a due diligence examination to private companies? It's not often that you want to let out who your owners are in general. A lot of times, as indicated before, that's something that you want to keep confidential for various reasons. Does this change the balance there of when you can do that? Go back to that 20-person exemption where you need at least 20 employees to be over that threshold and thus out of the reporting. A lot of times shareholders or LLC members are working with the company but are not classified as employees. Do they get counted? Even if they're active in the business, but not necessarily an employee for whatever reason. I indicated before how broad is applicant. Does it include the secretary doing the typing? Does it include CT Corporation that does the filing, electronic filing or otherwise? What else does an applicant have to do here? Is that going to be a target of compliance for the government? I guess we're going to see. And then this whole exemption thing is still sort of unclear in my mind. Do you have to file if you're exempt, or are you just automatically exempt and so you don't need to report? Again, is it the company that needs to report that? Is it the individual owner? Because the company could have beneficial owners that do have to report and some that don't have to report. So it's going to be an interesting time, as I say. So I've started to make a list here of things that we can do now, start to do now, some things I've started to do. Putting in engagement letters that the clients are going to observe these obligations to at least start the process of making sure that it's the companies that have to do the filing and not the attorney that gets stuck with it. Within the companies themselves, I think you can now start to put in shareholder agreements, operating agreements that your owners are going to cooperate and provide the information that you need, their driver's license number or whatever. Have the owners, the beneficial owners, consent to this disclosure of pretty private information. Might as well get that process started. Certainly monitor FinCEN for the notice of proposed rulemaking and for the rulemaking for the regulations to come out. I think in general, regulations are effective 30 days after publication in the Federal Register, or maybe online now. So it is, as I say, going to happen very quickly, and they might ask to shorten that time frame for effectiveness, in which case the new companies are going to have to start filing maybe as early as the first week of January or something. I don't know. And watch this space. I think Alexis and I are going to monitor this, follow this, try to keep up with what's happening, and happy to share any further information that we learn, any more guidance that we see. And I certainly expect that some form of this presentation will be ready early in January, so that we can hopefully have a couple of weeks before the reporting requirements kick in, and help inform this group as to what's going to be required. And that's as far as we go, Elliot.
Great. Wow, that was alarming, is what it was. So as you go through it, yep. and one realizes, based on your analysis of it, how much ambiguity is embedded in the way the law is written at this point. It just seems like it's going to be a hotbed for misunderstanding and then dispute. So I have to, my first thought is, well, if I have a dispute about whether or not this applies to me, if I hear from FinCEN that it does apply, but I thought that it didn't, what is my mechanism? Is there some internal process, like with the USPTO, where they've got a tribunal and a way for handling specific types of dispute, or is this all going to be handled through the court system? How do we resolve the ambiguities procedurally?
I haven't seen that part discussed here. I don't know that there's any built into the statute. I mean, I think they think this applies, and it's all going to go swimmingly.
Right.
Let's hope the
I
regulations.
I agree. I don't see anything in the statute that lays out that path.
So it'll be up to the court system, the federal court system, because it's federal law.
One would presume, I suppose.
Yeah, again,
okay.
Maybe the regulations will provide some administrative process to figure this all out.
Okay, yeah, I would expect that we're going to see a lot of case law develop from January 1 of next year forward, and probably in 3 years it'll be more clear. But there's a surprising number of ambiguities revealed by your analysis there. I guess one thing I want to be as clear on as I can is what are the exemptions, if any, for small and medium-sized companies? I'm not clear on whether you have to be above a threshold or below a threshold to be exempt from a reporting requirement. What is it? Yeah,
focusing on that 20 employee, 5 million in revenue physical presence, you've got to be over those limits to not have to report, to not fall, to be exempt, I guess, from the beneficial owner definition. Again, do you need to file to get an exemption? I think that still needs to be determined. But I think being above those numbers is going to be helpful. I mean, what they're trying to do, obviously, is to prevent too much of a burden on companies that are actually doing things and are physically here and are out and visible and revenues and people, and those apparently aren't sources of money laundering.
Interesting. So it's the small and medium-sized companies that will have more or fewer exemptions. They'll have fewer exemptions and more reporting requirements. Is that right?
Yeah, I guess that's right. I mean, you look at the dry cleaner down the street with 6 people, and they're making $100,000 a month or $200,000 a month. Well, that's way under 5 million a year. They've got the physical presence, but they're under the employee number. They're under the revenue number. They're going to be reporting companies.
Right. It's essentially the least sophisticated of the owners, most likely, are going to be required to report.
and the folks that can least afford the cost of compliance here too, of course.
Right.
But again, I guess that's where the problem
penalties
is.
associated with non-compliance. Yeah, that's an interesting feature, which kind of reverses, it seems to me, many exemptions under federal law, where if you're smaller than X, you don't have to, is the typical provision that I encounter. But this is quite different, and one can understand from a law enforcement perspective why this doesn't make sense. But yeah, it seems like it'll take folks by surprise if they're in that category and not accustomed or not equipped to understand how the law is changing in ways that applies to them.
Yeah.
Exactly.
Yeah. So there's some prosecutorial discretion in pursuing this stuff, but I guess we'll see.
Yeah, I guess we will see. Are there other questions? If anyone wants to jump in and give voice to a question, you're welcome to do so. Feel free to unmute yourself and join the conversation. Or if not, feel free to continue using the chat. I do see a question here from James Reyes, a former chair of, in fact, the former chair of this section. And James, would you like to voice your question directly, or would you like me to do so?
Well, I'll go ahead and ask. I know that there's a beneficial owner provision, but in terms of foreign non-Michigan companies which are registering wholly owned subsidiaries into Michigan as new entities, what would be the responsibility to continue up the chain? Let's say we've got a New York holding company of a Singapore entity, and that New York holding company files a Michigan distribution subsidiary. And how far back do you have to chase this?
I believe, that the regulations this statute would apply. So then the reporting would be required. Of course, it would need some analysis if any of the other exemptions would apply, and subsidiaries of exempt entities are an exclusion or an exemption. But if an exemption does not otherwise apply, I believe they would certainly be subject to the statute and be required to provide this personal identifiable information for each individual beneficial owner and applicant.
Yeah, up the chain, I think. So yeah, your Michigan company probably has a filing obligation, and its beneficial owner is the New York company. Well, there's no individual there. The New York company itself has a beneficial owner reporting requirement, presumably, and it goes up. Oops, there's a Singapore entity there, no individual. Do you then have to have the Singapore entity disclose its individual owners or further up the chain? I think that's certainly the intention. I mean, interesting what sort of number could Singapore individual have to report, I guess passport number, or they have to register with FinCEN to get a number. But how do you chase that individual if they're 3,000 miles away? So I think the obligation is going to be there. Maybe then the enforcement is against the New York holding company that doesn't do what it's supposed to do, but who knows?
And my follow-up
again,
is
see the regulations. I hope.
My follow-up is: will the state of Michigan do anything differently through LARA if FinCEN notifies them that there are companies which have failed to report?
We don't understand that the reporting relationship will be that way. I don't believe that FinCEN is going to be reporting that to our office within LARA. Instead, we'll be required to give FinCEN certain information that they're developing in the regulations, but it's not my understanding that the statute is written that way whatsoever.
So legally, we would still have a Michigan entity which would be protective of liability for the ongoing operation through that issue of reporting to FinCEN. But
yeah, I think that's right. That I don't think that
Yeah.
this affects the corporate status of the
Right,
entity
correct.
itself. It just may or may not be in violation of this act.
you know,
Exactly.
since the Immigration Act really of 1980, the U.S. government has been imposing on different actors obligations to become, you know, sub-agents of the federal government through various tasks they're required to do. For this type of thing, if attorneys become responsible reporting parties for representing their clients, then if, as Mark, you raise, their former clients who are no longer in an attorney-client relationship, and yet we're being imposed upon to track this down and file information about former clients, we're basically being asked to perform services without any compensation, which should itself be a violation of federal law. So,
Yeah, James, you're exactly right in terms of the. I guess we're imagining worst case scenarios, but they're not certainly out of the picture scenarios, out of the question scenarios. It certainly could happen.
Agreed.
So-
And that kind of constitutionality behind it as well. And even as a state filing office, that did come to mind myself with some of the mandates that will be coming, whether they're then unfunded and whether the constitutionality around that. But perhaps they will accompany with some funding to carry out what they're requiring.
thank you.
So another question, Alexis and Mark. I'm glad that you have commented on the rules. And I think that given all the questions you've raised, hopefully those questions have gotten through and will be addressed in the regulations. But if others want to comment, how do they comment?
Sure. So going to regulations.gov is where the regulations will be posted. So I commented on the advance notice of proposed rulemaking, which was really several pages of questions that FinCEN was posing regarding whether they should clarify certain terms or provisions of the statute, and definitely indicated they need to provide a lot more clarity, and there's a lot of ambiguity there. And also the position that we took as well was to encourage them to develop a tool, an online tool, or kind of like a wizard in a way that walks someone through these different layers of analysis to then reach a conclusion of what reporting requirements are there for that entity or that individual. So that way they can help make that determination, because some of this would be considered legal advice in a lot of ways. And as a state filing office, we cannot provide legal advice. So we see those questions coming our way and want to hopefully have FinCEN take care of that for us. So in July is when it's tentative that proposed draft regulations will be released, and then a comment period of 60 days. So it won't be that long, but it does seem to be enough time to review those and submit some comments so the public can comment in those 60 days. And then they're, of course, required to take those comments into consideration before issuing the regulations.
Fascinating. So we've come to the top of the hour. I want to thank our presenters, Mark High, Alexis Lupo, for a fascinating discussion about a new law that does seem to have surprising ramifications on business in the United States and people who do business and owners and all this. I'm glad that you set out the action to take now slide. So I thought that was real helpful to understand, to be aware that, oh yeah, there are some things we can do now. And in fact, I took notes on those three things. So do you mind if I distribute your slides to the attendees after this meeting?
That's fine with me.
Yep, definitely.
Okay, maybe you can send me an updated copy so I'm sure that I'm distributing the latest copy, and I'll do that. But why don't we close out with maybe 30 seconds from Alexis and then from Mark, and then we'll call it a day. So thank you so much, and we're delighted to have you here today.
I don't think I even need a full 30 seconds. I would just thank everyone for this opportunity. Tell your colleagues is the, I guess, another step of action you can take. I think that there are a lot of practicing attorneys that are not aware of this requirement, and it's definitely a monumental change. And I think they should be aware of it. So thank you all, and I am sure we'll follow up with you in the future.
Mark?
Yeah, I'm about at the same position here, that this really is like a crusade to try to get the information on this out. A lot of this, as you indicated, is going to fall on the smaller companies down the road. But the reporting requirements for new entities are going to kick in right away. And that's going to apply to everybody, from the Dickinson Wright folks down to Gaylord or whatever. Whenever you start a new entity, you're going to have to, somebody's going to have to make this filing come January, February of next year. So lots to learn here, lots to pay attention to.
Great. Well, thanks to all presenters and attendees as well. And we look forward to seeing you at our next, which should be on January 7, and you'll receive more communication about that. Take care, everyone.
Great. Thanks.
Bye.